everyone, and welcome to the Vegas Legal Podcast. I'm Mark Fierro. I'm here with Vegas Legal Magazine publisher Tyler Morgan, Fierro Communications Vice President Jeff Haney. Thank you so much for joining us today. Today we're going to be talking with one of the most unusual plea negotiations in Southern Nevada history. The defendant, Rod Suda, was charged with open murder. The 24-year-old defendant could have spent the rest of his life in prison, but the deal was negotiated down to a gross misdemeanor with not a single day in jail. Joining us today, one of the most respected names in Nevada legal profession, attorney Dominic Gentile of the law firm of Gentile, Cristalli, Miller, Armani, Savarese, the man who represented that defendant, Mr. Suda. Thanks for joining us today, Dominic.
Thanks for asking me.
One point of disclosure, we're friends, soon to be partners. We've done a lot of cases, and we worked on this case together.
We did.
One of the things that I've heard you say in the past, and in particular about this case, this is the defense attorney's nightmare, a person who is truly 100% innocent, and the only thing that you can do is detract from that in some way.
It is truly a nightmare. I mean, as we were saying a little bit ago, I'm going to be finishing 46 years of doing this for a living in just a few weeks. And in 46 years, oh my God, I don't think I've had 25 innocent people in the sense of like a baby is innocent, okay? Did nothing, just was in the wrong place at the wrong time. Somebody got it wrong and they were accused. And I could probably, given enough time, name every one of those because it just takes so much out of you. It's the greatest challenge that anybody who defends the citizen accused can possibly face.
This was, on the biggest headlines, one of the worst fact patterns that you can imagine. The deceased, 13 years old, 7 shots, what appeared to be all to the back and head. On the other hand, Mr. Suda, early 20s, literally an altar boy. And he's cornered, finds himself cornered. When you first get this case, what did you see? What were you thinking?
He, as you said, literally was an altar boy. He served mass. His priest is the person who went with him to the police department when he gave his statement. He didn't bring a lawyer. He brought his pastor. And Rod was an innocent. Rod is still. He's a lot more savvy now than he certainly was 15, 16 months ago. But yeah, I was dealing with a person who was certainly new to me. I don't often deal with people that are just that wholesome and innocent and naive. And he was defending himself. And what I had to begin with was the video of the actual event. And it was clear that there was a person who was 5'9", who had a mask on. His entire face was masked except for his eyes. He had what looked like just a hooded sweatshirt on. It turned out to be 3, and was running right at him in a way that it was impossible to be able to determine what his motive was, but you knew that it wasn't good. And you know, when you start with something like that, the first thing that comes to your mind is self-defense. That was the first thing that came to the police's mind because they didn't arrest him that night. They let him go home. And it wasn't until 4 days later when a couple of policemen made a mistake. Actually, one policeman who attended the autopsy made a mistake in his report. And he said that all of the shots went in the back and came out the front. He was half right. All of the shots did go in the back. 2 of them traversed the body, went in one side of the back and went out the other side of the back, which clearly indicates that the young man who died was not running away. He was turning as he was running toward him. And that's what we had to start with, but because of that one mistake, and I'm not even suggesting that the policeman did it on purpose. I don't think he did. I think he just made a mistake. But that one mistake caused this young man to have to live for almost 1 year looking at the possibility of life in prison.
He was in the video, you can see, and the video is so unusual in that there's probably 3 separate cameras, 3 separate angles that you have, varying degrees of quality. But he is so stricken in the aftermath. In the very first thing, you talk about whatever the opposite of mens rea is, that split second he reaches for the phone to call 911 to tell police that this guy is down. And by the second, you're watching a human being falling apart. What happened? How did this happen? Why me? Why did they come for me? Why did they do this?
He actually says that. And if you listen to the 911 tape, he's sobbing throughout. And he's
hysterical.
He's hysterical. And he is, in fact, going through an emotional breakdown at that moment. And but still had his wits about him to be able to call to try to get help for this young man. There was no way of helping this young man, but Rod didn't know that at the time. And he's in agony. He really is. Rod is on that telephone. Why me? Why me? And he said that over and over again, and sobbing. And you could tell from, I've listened to a lot of 911 tapes in my career. You could tell that the dispatcher had tremendous empathy for him. She was trying to comfort him, while at the same time having him listen to her so that he wouldn't become the victim of the police if they arrived and they saw him with a gun in his hand. To his credit, and the dispatcher wouldn't know it, he had already put the gun, he had emptied the weapon and placed it on the countertop as he was dialing the telephone. So he had the gun in one hand and the phone in the other. He put the gun down and started calling right away. It's really something. We're in the process of putting together, and when I say we, I mean my office. We feel so strongly about what happened here and how rare it is that we're putting together a film short, in the nature of a documentary, that we are going to distribute to basically middle schools and high schools so that young people can see the kind of horrible outcomes that can occur when they think they're just goofing off and just fooling around. And that's what happened here.
So just real quick, circling back so that everybody kind of understands the picture that we're trying to paint here. How did this all start? Because he's working like in a convenience store counter, and then all of a sudden it's like a group of kids, which look like grown men and adults, come just barging in wearing masks and everything. Sort of like recap and paint the picture.
Sure.
So that everybody knows.
Sure. Rod Suna did not work in the smoke shop that he was working in that day. He did a favor to the new owner of that shop to relieve that person for that shift so that he could do something else. Rod carries a weapon lawfully, and it was exposed. It was on his hip in a holster because his regular job has him going around our community collecting cash. And so he keeps the weapon on him during the course of his regular business day because he usually has a lot of cash with him and he's susceptible to being robbed. Unbeknownst to him, he's actually on the telephone with his girlfriend singing "I Want a Hippopotamus for Christmas." That actually came out. They're having a grand old time. You see it on the video. And then all of a sudden this door opens and 2 young men dressed the way I described it earlier. The mask is called a shamag. I had never heard that term before, but it is the type of mask that you see in single-person shooter games and when we see terrorists on television. They had actually planned this. There was no way for Rod to know that what they intended to do was come in and steal a bong because one of them was in possession of marijuana and they wanted to go out and get high. I think their ages were, 13, 14, and 15. And they had terrible school records. One of them had a long juvenile record, and they were just the kind of kids that were using drugs and goofing off. The kind that turn into donkeys, if you are a Pinocchio fan, all right? And so we actually had a video of them preparing for this in the magic store next door. They were in the vestibule, dressing, wrapping the shemagos around their head and all of that. So they have no thought whatsoever that they're going to be barging into a store where someone's armed. I'm sure they didn't, because if they did, they wouldn't have gone in. Certainly not that way. And their whole purpose was to go in there and to rob the store. Now, whether they were going to stop at a bong or not, it's not just debatable. I don't think they were, because if they were, there was no reason for them to split up when they came through the front door and one go left and one go right. My thinking is they wanted at the cash register. And that's where he was. He was standing at the cash register when this young man was running right at him. Rod is not the kind of kid that would have shot just to preserve the money in the cash register. He would not have done that. And I think that when anyone sees, and of course we had a focus group where we had 16 people look at it, and I guess we're going to talk about that in a second. But when anyone sees it, sure, the first thing they think about is, well, the kid was unarmed. Sooner or later, they come around to realize that there was no way for the shooter to know that the kid was unarmed. And as a matter of fact, the other kid had a butterfly knife in his pocket. Now, that's not something that Rod could have seen at the time, but one of them was armed with a kind of a device that could kill you. So, it's a sad event. It's a sad event all the way around. Rod is not the kind of a fellow who would have wanted to kill anybody, most certainly an unarmed 13-year-old. Those kids, they were on a track that was going to lead them to something tragic in their lives. I hope that the two that survived this got a message, and it's not too late for them to maybe get off that road and on the straight and narrow. But these things happen in life. They happen every day.
Jeff and I sat there for a week on that video in trial prep and watching that door fly open and the two perpetrators split up, very, very well choreographed, moving at almost the exact same pace, coming towards Rod, realizing, we know while we're watching the video, Rod has no way out of this. There is a door behind him, but it is completely useless to him. He cannot get out.
No, he can't get out. The back door that would lead to the alleyway, or the part behind the store, let's put it that way, was not only double locked, but there was a barred door between the store and that door. And in front of that, there was something, I forgot what it was. I think it was a file cabinet. So, and Rod knew that. Rod knew that there was no way for him to run away.
There's no way out.
There was no way out. One of the things that the Justice of the Peace, Karen Bennett, asked at the preliminary hearing was there an escape route? And we presented the photograph to her. Now, in Nevada, you don't have to take the escape route in order to comply with the law, but I think the average person would rather escape than have to kill somebody, or even take the chance that they might miss and then be killed. So all threats are met with a fight or flight response. And I think that in that situation, the average person even if armed, would flee. I think Rod would have fled had he had an opportunity, but he knew that he didn't.
Well, another thing that made this case unique is the detectives who were on the scene to see everything, to see the layout, to see what Rod is going through. The fact that he's sitting there with a priest instead of an attorney, he doesn't lawyer up, he priests up. Mm-hmm. And they ask him all these pertinent questions that we're talking about. And when they're finished with that on tape, on camera interview, the one cop explains to Rod what's going to happen next. We're going to take this, we're going to transcribe every word that you've said tonight, and then we're going to submit it to the district attorney's office to see if he agrees with us that no charges should be filed. They felt that this young man was innocent.
At that moment, they did, and it wasn't until the autopsy and that error in the report. You have to remember, they work with each other and they need to depend on each other, and they do every day. The problem with that is that if one of them makes a mistake, the remainder of the team is going to believe that it's not a mistake. They're not going to try to fact check it, and they're going to proceed based upon the accuracy of what that officer wrote in his report. And as I said, he was half right. The bullets did all go into the back. They didn't all go straight into the back. Mm-hmm. All right? What he said is that they went in the back and came out the front. And when we went to see the medical examiner, when we went to interview him, which, by the way, was a fluke. It was just an idea that Don Dibble, my investigator, said, why don't we just go talk to him? And I thought, okay.
Can't hurt.
It can't hurt. So we went and talked to him, and the first thing that man said to us was, I don't understand why they charged your client. And Dibble and I looked at each other and, you know, why do you say that? And he said, well, take a look at the drawing that I did from the autopsy. And I said to him, we didn't get it. The DA never gave it to us. So he went and looked, and he retrieved it and showed it to us and explained to us what happened. And it turned out that the district attorney's office never had it. We ultimately gave it to them. Now, a second mistake. I mean, it's not a DA's mistake necessarily. It might be the law enforcement, Metro mistake. But ultimately, at the end of the day, it is the DA's mistake because the DA needs to. The buck stops there. That's what it really boils down to. The buck stops there. And, if Steve Wolfson had known that the bullets did not go out the front, and if Steve Wolfson had known and had seen, or even one of his deputies had seen and shown him this drawing from the autopsy, I know Steve Wolfson a long time, and I have the highest regard for him, and he would have never approved these charges being filed. But they were filed. And so at the end of the day, especially after a year, with a 13-year-old victim, he's got a political problem on his hands. And while I wish our system was perfect, it isn't, it never has been, and it never will be. And that's the reason that defense attorneys have an important role.
This is a very, very interesting development that happens next, and that is because there are things that appear to be a line call, because there are cops saying things on both sides of the equation, you make the decision to go with a focus group, and let's see how this thing plays. And when it opens, it is not good. They immediately, every 13-year-old, who's the shooter? He's guilty.
Why didn't he fire a warning shot?
Yeah.
Why didn't he shoot into the ceiling?
Roy Rogers.
Not realizing that if he had done that, he might have killed somebody upstairs that wasn't threatening him, Yeah, exactly. Too many Western movies. But, yes, that is what happened. And this case, as you know, Mark, because we've done them together, I've been doing focus groups for decades. But not always, not in every case. I am beginning to believe that that there's a whole lot more cases that should utilize the benefit of a focus group, and early. In fact, I have one right now where it's one of my partner's cases, and it's a personal injury case, and we haven't even filed the lawsuit, but we're going to do a focus group on it. This case lended itself. Any case that has video lends itself to a focus group. Any case, because you don't have to tell the story. The video is there to tell the story.
That's what's going to tell.
So there's no credibility issue in terms of, well, is the story being accurately reported? In this instance, we had the videotape of the actual event. We did not have the videotape yet about the next door, as I recall. Honestly,
There was word that it was out there.
it was word that it was out there, but we didn't show that to the juror, to the focus group people. And all we did was we gave them the very worst evidence, the stuff that the DA would definitely use to prosecute the case, and the set of jury instructions. That's all we did. We didn't really do anything other than that of any consequence, as far as I can recall. And I remember discussing with you whether we should or not. My view of it was, let's see what the worst case scenario is, and let's see what they're talking about. And sure enough, you're right. They started off with a 13-year-old. You killed an unarmed 13-year-old.
Yep. How much worse can it be?
And by the end of the focus group, and we split them up into two, because we wanted to see if there would be a difference.
How many people do you put in the focus group?
That one, I think we had 14. I think we had two groups of 7. The one we just did, we had 16. We had two groups of 8. But both of them started off against Rod
100%.
and the person in Rod's position. And as they discussed it with each other, and as they talked about what they saw in the video, and particularly as they went through the jury instructions that the jury would be given, both of them resolved it as self-defense.
On their own?
On their own, yeah.
On their own.
There was no presentation made to them with regard to the legal argument, none whatsoever. And by the way, to the extent that that can be done, that should always be done.
This was so clear-cut, because to take your role for a moment, there comes a time in every case where, when the real negotiation is done and the case is what it is, the offer is what it is, the client's going to turn to you and say, what would you do in this position? What would you do? And in this case, having that focus group, being able to say, they can't convict you. Don't take any deal, no matter how minimal it sounds, because when you're looking at life, 5 years doesn't sound so bad. 3 years doesn't sound so bad, because we marched down. We marched open murder to second-degree murder to voluntary to involuntary to parking to, they literally did that on their own without ever, you never once offered a counter deal, did you? Ever once?
No, the only thing I ever offered was a dismissal.
There you are. And so when you have a focus group in your pocket and you know what's about to happen, it puts steel in your spine. You've stress tested your ideas.
We could not have held as tough and strong as we did, but for the existence of the focus group and knowing what people in the community who are not lawyers were likely to do in response to this fact pattern. And again, they did it without any defense being displayed to them. And so if the video itself spoke self-defense, you can't get any better than that. And this is really the first time we're going public with the fact that we did these focus groups. And if the DA watches this,
which he will.
Well, maybe he will, but if he does, maybe he'll think that I'm not as crazy as he must have thought I was to be holding as tough as that. I can tell you this: when we went before, I wasn't there, but Paula, my partner Paula Armeni, who should be given a lot of credit for this case because she was there every step of the way. She appeared before Judge Togliatti at the calendar call, and Judge Togliatti has this procedure that she uses where if there has been an offer made, then she makes it part of the record because she doesn't want the defendant to later on say, well, my lawyer didn't tell me. And I'm shocked that that happens, but apparently it does happen. So as the DA is telling the judge that what they offered at that time was a plea to a felony and a period of probation, and if at the end of the probation he successfully completed it, they would reduce it to a gross misdemeanor. Judge Togliatti, according to Paula, Judge Togliatti kept looking at her and looking at Paula like, are you crazy? Why are you turning this down? And 3 different times said, oh my God, oh my God, oh my God, you're turning this down. And I got to think that Judge Togliatti must have thought we were lunatics as well, except that we had tried another homicide case in front of her open murder case with a self-defense and a video, and we won an acquittal in that case. And so Judge, she probably didn't think we were as crazy as others might have. But without the focus group, we could not have done it.
Yeah, you never would have taken a leap of faith, particularly with a young defendant facing the possibility of the rest of his life.
Right. I mean, when you're given an offer of plead to a felony and stay out of trouble and we'll reduce it,
That's hard that's hard to pass up.
well, let me tell you something. I've talked to judges and prosecutors and defense attorneys around the building after this case. This is the only time that it's happened. It has never happened before, based on memory of the collective memory of people that do this every day for a living. So in that sense, it was a really unique and wonderful result. I'm not happy with it because I don't think he should have had to be found guilty of a gross misdemeanor. But how do you turn it down? You know, you're looking at the possibility of a jail sentence of 364 days, which the DA argued for. They did seek that. But Judge Togliatti, in her wisdom, realized that the only reason we pled to anything is because it eliminated taking a risk. And she also knew what that earlier offer was that we turned down. And so she ultimately gave him probation.
So with the confidence that you had out of the focus group, how hard do you think it was for your client to keep his confidence and composure and let you do your job and fight the case without him thinking halfway through, oh man, maybe I should just take the deal, maybe I should just take it, you know?
That buys another story, so I'm going to tell the story. My client is a very religious man, and he's from a family that is Armenian and Jordanian, and very, very closely knit and loving people. I mean, an old-fashioned family in the sense of its size and it's how extended it is. My client never, ever gave it a second thought. He trusted me from day one. His father also trusted me from day one and paid his fee. But it was his son. It was his blood. And there came a time when that penultimate offer was made, the one before the final one, when it got tough for Dad to say no. But within a matter of, I think the second time we all met at the beginning, Rod's father basically gave me Rod. He said, he's now your son. He said, he's in your hands, and we trust you. And they did all the way through.
This was more akin to a film. These negotiations that we're talking about are not spread out over months. We're talking about the last hour and a half before we're supposed to go. This is the last day before we start trial.
The deal was struck at 5:28 p.m. the last day before we were supposed to pick a jury at 9 a.m.
And one of the decisions that helped keep Rod out was that he and his father saw the focus groups. Remember, these are two groups that are formed, that have heard the same information, but then split off into two rooms, and they both came up with the same outcome he's innocent. And that's what steals everybody. Dominic and I look at each other and say, we need to be in this business. We need to go in the focus group.
So what's the endeavor in a focus group? Because I think you're saying not enough attorneys are using focus groups, and I would think that the deterrence of using a focus group is the incorrect thought that it requires so much more time and effort and money, and that it's only for more complicated cases, and that you just can't utilize it on a regular basis. But talking with you, you make it seem like it's very easy to get through, get the people in and out.
This was an afternoon. And then plus the work that went into it was to take the information and just boil it down to its salient issues of the prosecution's case, made basically 100% of their case for them, and we put in basically nothing of ours, just to see what would fly.
Well, I think if you ask Jeff or me, we'd have a whole different view of that than
Well, we were ready to go.
because it was way more than an afternoon.
I'm talking about the focus group itself, and we sat there.
The focus group was, if you think about it, it was all day. We started early.
Yeah, by the time
we were finished with the presentation early, but I want to say that the two focus groups deliberated about 3 hours or more each. But that's picking nits. It's not what's important here is the plaintiff's personal injury bar and the defendant personal injury bar use focus groups a lot, and have historically used them a lot. But those are guys that really do go to trial. Those are lawyers who really think that they may have to go to trial, and they want to learn the most they can about their case. 90+% of people who are charged with a criminal offense either have a public defender represent them, in which case there's no budget for focus groups, which we are trying to make affordable for the public defender, by the way. It's going to be part of our mission. And the remainder are lawyers who never go to trial. Never go to trial. They never tell their client that they never go to trial, but they don't. And so they're not even going to think about doing it because they don't really care what a jury might do, because they're never going to present it to a jury. And they know that the day that the case comes in, and it doesn't matter what they charge for a fee, they're not going to go to a jury. They're going to make a deal and move on to the next case. Fortunately or unfortunately, I'm not sure which, it depends on the day you ask me. That's not the way our law practice works. Just about everything that comes into our office, from day one, we think in terms of it may have to go to trial. It's just an approach, it's just a philosophy. It doesn't make you better or worse, but it's just the way. And so as a result, that's the kind of stuff that comes to us. And I will say this, there are probably in our community today 20 private practitioners who do criminal defense work that do in fact take their cases to trial. There are probably another 50 public defenders that do. And it's really that niche, that group, not exclusively that group, but particularly that group, that we want to teach them the value of a focus group and how it can improve the result, or even the negotiation. Even the negotiation, because in this instance, let's remember that we did not take it to trial. We wound up negotiating it, which I would have bet anything would not have happened. But when the deal gets as sweet as it got,
there's no way in the world.
There's no way in the world that a lawyer in my position, despite how much I wanted to go to trial in this case, could say to a client and justify it, trust me, I can win this case.
All right.
You're not going to jail if you take this deal, but trust me, I can win this case. At that point, it's all ego.
Yeah, I happened to be in your office that late afternoon when the final offer came in. And could you just describe the kind of the atmosphere and the emotions on your team at that time?
I can draw an analogy. When I was a young man, I worked at Arlington Park Racetrack in Chicago. I got to deal with a lot of horse trainers and jockeys and stuff like that, and learned a little bit about racehorses. And when a racehorse, particularly a quality racehorse, is training for a particular race. If that horse gets scratched and does not run when scheduled, they will kick down the sides of a stall. And that's how I felt. I was so ready to start trial that despite this wonderful result, according to everybody else's point of view, and now my own, despite that, I was not happy at all because I was ready to go.
In the moment, you were stepping into the
Yeah, you
starting
saw
gate
that,
there,
didn't
right?
you?
Yeah, I saw the whole thing unfold, and it was rather intense. You could see the emotions and the intellectual debates going on, and it was a big moment.
Well, there's nothing that a real trial lawyer, and I humbly consider myself to be one, likes better than to hear a jury say, "Attaboy." Okay? Nothing. And in a sense, and again, it's ego, and it's not right, but in a sense, that's what I was cheated of, which is why, because I knew we could win the case, which is why I was walking around looking as miserable as I was when everybody else was so happy.
Throwing hats. It is an amazing thing, particularly on paper it's one thing, but to be around Rod and to see that this could have been a life completely wasted, completely devastated. That was what was on the table.
Well, I don't know if you ever saw the video that my son Peter did for sentencing, but Pete's done a few of these. He's a film guy, and what he did was he interviewed about 15 people in Rod's life, and the reason we did the video is because we could make 15 minutes of video available to the judge when we knew she'd read it, see it, as opposed to having all these people come into a courtroom where they're uncomfortable and they may not project. Their affect would be different than at its best.
Perfecting the message.
Yeah, absolutely. And if you see the wonderful things that these people had to say about Rod and his family, it makes the point that it underscores the point that you just made. I mean, this is a young man who will do good things for people in his life in the future, and would never have done a bad thing for this young boy who died. Rod wasn't about to go outside and say, "I want to go kill a 13-year-old." All right, that wasn't part of his destiny. But on the other hand, self-preservation is without a doubt the strongest passion that we have, and that was triggered.
And whatever else Rod is, he was the victim of an armed robbery about a year before, as I remember.
No, he was in high school.
Stuck a gun in his ribs. And
yeah, his brother and Rod were in a car, and they picked up a friend who had two friends with him. Friend, most abused word in the English language, but and one of the kids stuck a gun in Rod's face and basically robbed them. And so he had been the victim of an armed robbery about 5 years earlier.
This was a tough case. This was the best outcome. The only guy that I know that walks away with a gross misdemeanor, no time served, and says, "Why me? Why couldn't I have walked him?"
It's a really interesting story of understanding the potential of consequences, because as the kids, they were thinking, we're going to go in there and get a pipe to smoke, and we're just going to steal something simple. They don't realize the significance of what that can lead to. And then on the other hand, being on Rod's side, defending yourself, how things can sort of get twisty and twirly and sort of go against you. So it sort of really makes it, it's kind of one of those cases that really makes you sit and think.
And not only that, but it all happened, remember this, in just a matter of seconds, just a few short seconds.
Under 3. I think Dibble figured it to be 2.9 seconds.
That's from the time the kid first showed up in the door and charged and jump the counter. Just that number of seconds. That's all. That's almost nothing. It's not like it is in the movies. It doesn't happen in slow motion. It happens just like that, and it's over.
Jeff and I sat in the room in your office when we were preparing, and we watched this slow motion video, frame by frame by frame, watching where Rod's eyes go, where the kid is standing. And over again, we would stop and we'd look at each other and say, this cannot play in the courtroom in slow motion. This is not what Rod was confronted. Rod was confronted with a split-second decision.
And ultimately, we had to hire an expert from Illinois who does and still does all of the police training for shoot, don't shoot for all Illinois police departments except Chicago. And he broke it down. I don't even remember how many frames in a second did he have it at? A couple of hundred?
Yeah, we're at 30 frames a second. I think the surveillance was at something like 9.5 frames.
And I think he broke it down to 180 frames a second. And we had to do that in order to demonstrate that these bullets did not go in the back and come out the front.
No.
All of this because a policeman, for whatever his reasons, and I don't think any of them were malignant, didn't listen to the medical examiner. I mean, really, that's what happened. That medical examiner never said these bullets went out the front. He said they went in the back. And the cop finished his sentence for him. And that's the world we live in. Some people might blame that policeman. You know, but I'm sure it wasn't his only case. I'm sure he didn't mean anything bad by it. He had no reason to want to make Rod go through what Rod in fact has had to go through. And it happens. And it happens a lot. That's the sad part. It happens a lot.
Amazing case. And when it comes right down to it, in many ways, Rod's life and the potential that his life holds was saved by jurors, not impaneled jurors at the district court, but in a focus group that changed direction.
It's really saved by the court of public opinion.
Saved by the court of public opinion.
Well, I would have never put it together the way you just said it, but you're absolutely correct.
And with that, if you are a civil or a criminal attorney and you are interested in hearing more about how we can help you with focus groups, research, and mock trial, call us at 702-743-0816. And with that, we will call it a day. Las Vegas Legal Podcast. I want to sincerely thank our guest, my friend and partner, Dominic Gentile. And thank you, Tyler Morgan, publisher of Vegas Legal Magazine. Thanks for doing the good work and bringing some new life to the legal community of Southern Nevada. Jeff Haney, Vice President of Fierro Communications, the friendliest marketing firm in Las Vegas. And for all of you out there with a story idea, an axe to grind, get a hold of Vegas Legal Magazine, the leading magazine in Southern Nevada legal market. You can call Tyler at
702-222-3476.
Reach out, tell us, tell your friends. Have a good one. We're out of here.